I'm Mark Lathem, and I'm a lawyer who practices law in Richmond Hill, Ontario, in the area of real estate business and wills and estates law. And we've literally purchased thousands of new homes and condominiums on behalf of clients during the last 20 years. And the purpose of this video is to explain the typical new condominium contract and its implications for our clients and prospective clients. Please note, while there is some similarity between buying a new home and a new condominium, the process is significantly different, so we have dealt with this in two separate videos. My first observation would be that the purchase of a new home in the province of Ontario is basically a very safe purchase from the point of view of the contract itself, and the main risk that's associated with buying a condominium happens to do with the market conditions and not the decision to buy a new condominium from a builder itself. And that is because there's basically four pieces of legislation that impact the decision to buy and build a new condominium. The first is the Planning Act, the second is the Building Code Act, the third is the New Home Warranty Plan Act, and the fourth is the Condominium Act itself. And the purpose of this video, I'm going to go through each of those pieces of legislation and how they protect you as the consumer and how they impact you in the process of buying a new condominium. And the first is the Planning Act, which has, from a practical point of view, the least amount of impact on the purchaser of a condominium. But when the physical infrastructure for the building is put in itself, the water, sewer, and servicing, the developer has to put up a bond equivalent of the cost of the construction to prevent the new condominium buyer or the municipality becoming liable for the cost of completing the servicing. So the impact on a home buyer is fairly indirect. The second thing that is more direct is the Building Code Act itself. And the Building Code Act sets the minimum standards of construction in Ontario. It's policed by the local municipality, and where it really impacts on the purchaser of a new condominium is in fact the occupancy permit or the decision to issue an occupancy permit. The Act itself sets out when a municipality can issue an occupancy permit, and that involves two issues: the livability of the space and safety issues. And once the local building official issues that permit, the new home contract says that the buyer must close. So the good thing is that it's not up to the builder to decide when the buyer must move into the unit. It's ultimately up to the local municipality. The next piece of legislation impacts the purchase of a new home is the Ontario New Home Warranty Plan Act, which is administered by a government, or I would say quasi-government agency called Tarion. So you'll often hear New Home Warranty and Tarion used interchangeably. And what Tarion does, Tarion sets up a lot of the regulations regarding the closing and warranties and so on, but it really acts as a financial guarantor against a builder who may become insolvent. And in that sense, it acts as a bonding agency for you, the buyer. And what they do is they essentially guarantee up to $20,000 of the deposits that you've put up towards the construction of a new condominium if the builder should go bankrupt. Any amount above $20,000 is required to be insured through a separate process, and that's actually under the Condominium Act itself, through called excess deposit insurance. The second thing it guarantees the penalties that the builder will incur if they do not extend the transaction properly. And the third thing it does, it guarantees the physical construction of the building should it be deficient and the builder not be available through bankruptcy or otherwise to complete the items. And the warranty generally is 1 year for any particular item, any items in the building, 2 years for mechanical systems, which means plumbing, electricity, and climate control. And the third thing itself is the actual physical structure of the building: foundation, roof, walls, and water penetration. And that is covered for a total of 7 years by the Tarion Warranty Corporation. Now, the last thing is the Condominium Act itself. The Condominium Act itself governs the rules for building a condo and turning over the ownership to the unit owners. where the two big regulations which impact the homeowner is the actual regulation of what's called the interim occupancy fee and how it's calculated, and also the process about the time frames involved in that during that period. And it is the thing that requires that the builder obtain deposit insurance for any deposits in excess of $20,000. Now, what things affect a new home or new condominium purchaser? Well, the biggest one is the extension of the closing dates. And the bottom line is that new condominiums can be extended between the two dates that are put into page 2 of the Tarion schedule based on 90 days prior notice to the purchaser. If the builder does not give the 90 days prior notice of the occupancy date, then the builder incurs penalties under the Ontario New Home Warranties Act, and if they do not pay, Tarion will compensate them. It's just important to keep in mind that if you're selling a property to buy or having to give notice for rent, that until that time period has fallen to below 90 days before the proposed closing date, it could be changed. I would always caution a purchaser to phone the builder once you get to the 90-day mark and confirm whether there are any unexpected delays, because the Act still allows the builder to delay. It's just that a penalty falls into place. The next thing is what I would call the unfinished home provisions or condominium provisions. And basically what Tarion says is that if there are any other items not finished at the time the occupancy permit is issued and the builder moves in, an inspection is done, those items are listed, and they're guaranteed to be finished by Tarion itself. Now, the other thing that typically comes in with condominiums is what I would call the occupancy period. And what happens is when the building is built, the plans are not registered that allow the ownership to be given out for the unit. The building has to be surveyed. Those plans have to be approved by the local municipality and the land registry office before the ownership can be given. That period takes typically 6 to 9 months as of 2014, and during this 6 to 9 month period, typically the buyer is obliged to rent, although officially it's called an occupancy fee, the building from the builder. What the Condominium Act itself does is regulate how this fee is calculated. The fee is calculated based on paying the property taxes, the maintenance or condo fee, together with the interest on the unpaid portion of the deposit at the rate set by the government. Right now that rate is basically the equivalent of a 1-year open mortgage or 3%, so it usually relates to the existing bank rates right now. And that fee is paid every month until the final closing, when the title is transferred and the buyer delivers the rest of the money, often through obtaining a mortgage. Now the rules are basically you are entitled to 90 days notice of any delay or any subsequent delay of that closing date, that the occupancy period can run for a maximum of 2 years, and the builder is required to give 30 days notice of the final closing date, during which, like I said, this fee is paid. Now the other thing that impacts typically a new home purchase condominium are the HST regulations, and basically the new home condominium is sold on the assumption that a buyer is moving into it as a residence with a reduced amount of HST. If the person is not moving in, or an immediate family member is not moving in, then the builder must collect this on average 8% number on top of the original purchase price. And the way that is calculated is if the purchase price is less than $450, it's about 8%. If it's over $450, it's about it's a flat $24,000. A couple other things about the HST, 3 important points. Secondary residents, analogous to a cottage, do not qualify for HST rebates. There is a rental rebate which will see the government return exactly the same amount of money if the buyer intended to purchase it as a rental property and can prove that it's been acquired as a rental property by the submission of a 1-year lease, the application, and some of the closing documents. And the third category itself, it has to do with people that are flipping properties, and these are subject to the full amount of HST, with no rebates. Another thing, important point for those buying with the intention of assigning, there are very, very complicated HST issues with assignments, and absolutely you must consult a lawyer, quite frankly, who is familiar with the tax issues and HST issues involving assignments. The majority of real estate agents and quite a few lawyers are not familiar today with what those provisions are. The other thing that we want to go into is the additional costs in a condo. Typically a buyer will be given 10 days under the Condo Act to have a lawyer review the agreement and explain many of the items I just explained to you. One of the things lawyers have to do is check the agreement for additional costs. Typically a purchaser is buying the condo at a set price on the assumption they're moving in for the reduction in HST, and has agreed to pay the builder certain items in addition to the purchase price. And it's important that a lawyer look at that agreement to itemize them for you so they don't become a surprise on the day of closing. These are such things as the Tarion warranty, the deposit receipts, increase in development charges, meters, and miscellaneous charges. Now, in a typical condominium, these miscellaneous charges often add up to somewhere between $6,000 and $10,000. So they are very significant. And what is absolutely crucial in particular, the one that exposes the clients to the biggest surprise is the increase in levies clauses, and it's very important that the lawyer review the contract, identify whether there are charges that are not specified or capped, and try to get them capped to keep them below that $10,000 mark. And more importantly, just so simply you as a buyer are aware of what they are. Now, I think the final note I want to make about buying a new condominium has to do with the accuracy of the financial disclosure. The builder is allowed to make a lot of variations within the condo itself, including changing the size of the building floors, mix of commercial space and all that. And all of these things affect their estimate of the common expenses. And my general view is that estimates given by builders at the time they sell new condos are generally inaccurate. And there's that old expression, if it looks good to be too good to be true, it's usually too good to be true. And for the most part, I think that's a fair comment when it comes to the sales material that's given regarding the occupancy fee. The typical condo, what we're seeing is that the condo is being built up to 2 years late from when it was originally scheduled, and the fees have increased substantially. And when the builder is questioned about why their estimates in the sales material were not so accurate, they'll rely on the fact that the building was built 2 years later and there's been inflation. That's the typical story. The other problem that comes out is under the new Condo Act that was introduced in 2006, there's a requirement that the condominium corporation, once it's turned over to the owners, do a reserve fund study to plan for the long-term setting aside of funds to repair the building. What we're finding inevitably with most new buildings is that they're seriously underfunded. And often in the first 5 years following the construction of a building, we're seeing increases of the reserve portion of the common expenses that are an average of 20% for that 5-year period. And what we find is these buildings that are brand new end up having condo fees that are similar to buildings that are 10 years old with the same level of service. So my caution would be to take those estimates of the maintenance fees on new buildings with a grain of salt. Now, I'd like to close by saying that, in my belief, the purchase of a new home in the new condo in the province of Ontario is safe from any large financial risk except for change in market conditions. And like any contract, those small couple $1,000 problems maybe aren't dealt with so well in the regulations. But like I said, in a purchase of a resale home, in fact, they're equally as problematic. Now, I would also like to close by quoting Susan Elliott, who is a former treasurer of the Law Society of Upper Canada, in a video she produced talking about a lawyer's role in real estate. And what she pointed out is that experienced real estate lawyers such as myself, who often are closing 30 or 60 deals a month over a period of, in my case, 20 years, are going to be the most experienced people that they consult with in the purchase of a new condominium. We will literally have closed over 20,000 transactions during my career, and thousands of them being new homes and condominiums. And there are very few, if any, real estate agents, mortgage brokers, or other professionals that you're going to meet in this process who have that level of experience, which is frankly typical of a lawyer who has focused their practice as I have in this area. And I thank you very much, and I hope that you found this video educational and useful.